Hello, so my name is Eric Hall. I am so pleased to be here. I am a lawyer in private practice. I practice in Colorado Springs, which is where I grew up, with a private law firm, and our law firm has a religious institutions group, so we are doing religious liberty law all day long, and that is a great privilege. I was asked today to do the very technical part of this talk, and that part is describing to you all the Colorado Civil Rights Commission and its location within Colorado government and the details of how it works and what Colorado law is in this respect, because it was the Colorado Civil Rights Division slash commission that heard the Jack Phillips case for the Masterpiece Cake Shop. So what you just heard Eric Baxter talk about is a very important part about being a lawyer, and then I'm going to describe a different part about being a lawyer, which is digging into the statute books to describe the details of a specific area of law. So if you all are interested in being a lawyer, this might either move you in favor of or against being a lawyer. But here we go. So the Colorado Civil Rights Division, and it's called both the division and the commission, is a part of the executive branch in Colorado. So like with the federal government, we have the judicial, legislative, and executive branches. So we're talking about the executive branch. There are 8 principal departments in the executive branch for Colorado. They are the Department of Regulatory Agencies, and that's where the Colorado Civil Rights Division lives. And in addition to DORA, the Department of Regulatory Agencies, there's also Law, Revenue, Treasury, Public Safety, Local Affairs, Natural Resources, and State Personnel. So you can think of kind of the governor at the top, and then these 8 different branches, one of which is DORA, and underneath that, Colorado Civil Rights Division, okay? What does the Department of Regulatory Agencies do? Well, they regulate, right? Hence the name. Well, what do they regulate? They regulate professions, so they regulate lawyers, they regulate doctors, accountants, physical therapists, all sorts of professions. So they regulate professions, give licenses. This is your state government. And what else do? They prevent discrimination, right? And that's what the Civil Rights Commission does. They do it in employment, they do it in housing, they do it in advertising, they do it with persons with disabilities, and they do it with public accommodations, right? And the public accommodations part is the part that affected Jack Phillips, okay? So trying to keep this all organized here, those are the areas of the Colorado Anti-Discrimination Act, otherwise known as CADA, that the Civil Rights Commission kind of oversees. Okay, as to employment, you might be familiar with the EEOC, the Equal Employment Opportunity Commission, right? That's the federal level. The CCRD, or CCRC, depending on where you are in the process, is the state equivalent. Right? At the federal level and the state level, you can't go to court with an employment dispute unless you go through one of these agencies. Why? For a lot of good reasons, but one of them is to keep all these employment disputes out of the courts. Otherwise, they would overwhelm the courts. So you have to go through one of these regulatory agencies, either the EEOC at the federal level or the CCRD in Colorado. Okay, there is the division and the commission. First, the division. The division has a director, and the director is appointed by the executive director for DORA, after good faith consideration by the commission. Okay, what's the duty of the division? To receive, investigate, and make determinations on charges of discrimination. So if you feel like you're discriminated against in Colorado, you can pull this up online. Those of you who have phones or computers sitting on your laps, you could actually pull this up, and you could quickly Google a charge of discrimination, to file a charge of discrimination with the Colorado Civil Rights Division. And you can fill that out. It's a 2-page form. It's very easy. You fill it out and you file it, and then a charge of discrimination has been filed on your behalf with the division that they then investigate. So that's what the homosexual couple that came to Jack Phillips did, right? They came to him. They said, we'd like to buy a wedding cake from you. And he said, great, I sell wedding cakes. Oh, we're a same-sex couple, and we'd like to buy this wedding cake to celebrate our same-sex union. Now, at the time, Colorado didn't recognize same-sex marriage, so their plan was to get married in Massachusetts and then come back to Colorado where they lived and celebrate their same-sex marriage here. Jack Phillips said, I'm sorry, I don't, because of my religious beliefs, I will not sell you a same-sex wedding cake. And so what did they do? They filed this charge of discrimination, okay, against him. So then what happens next? Well, the division investigates. How do they investigate? They have what's called deputies. The deputies do the investigation. They can gather evidence. And at the end of that, they make what's called a probable cause determination. And that's a determination by, again, one of these bureaucrats to say, okay, is there probable cause that Jack Phillips, in this case, discriminated against this couple? And they found yes. Okay, so where does it go from there? Well, then you can, then in the Jack Phillips case, the commission said, well, one of our powers is to appoint what's called an administrative law judge. So they appointed an ALJ who then made findings about what happened. That's very important in this case and in every case, because any lawyer will tell you what wins a case? The facts, right? Facts trump law, and if you have the facts, argue the facts. If you don't have the facts, argue the law. If you don't have the facts or the law, argue the rules of evidence to try and keep the facts out, to keep the bad facts out. That's how practicing lawyers practice law. So it's very, very important to figure out who is your fact finder, all right? And so Mullins and Craig went this route because they knew this is the sort of fact finder they wanted to have. So the ALJ then made certain factual findings, and then where did it go from there? It goes up to the commission, and the commission is a politically appointed body. So the Colorado Civil Rights Commission, right, is part of the division, kind of paired together. They have 7 members. And the 7 members are appointed by the governor, and now, I think thanks to the Centennial Institute, in Colorado, they must be approved by the Senate. Before, I think they were just appointed by the governor. But you have to get your minds around the fact this is a political body, and there are certain rules about who can serve on this body. The rules are, first, they're supposed to be 7. They serve 4-member terms. 2 are supposed to be from the business community, 1 small business, 1 large business, 2 from state and local government, 3 from the community at large. The law says, the statute says, there's supposed to be diversity on the commission. At least 4 members must be from groups who might be discriminated against because of disability, race, creed, color, sex, sexual orientation, national origin, ancestry, marital status, religion, or age. So 4 of the members are supposed to be from groups that come from there, so identity politics, right, written into the statute. No more than 6 of the commissioners must be affiliated with a major political party. No more than 3 with the same political party, right? Democrats, Republicans. Right? If you have a Democratic governor like we do now, he can't pack it with just Democrats. You can't have more than 3 from any political party. And then for the geographical diversity angle, it's supposed to be as may be practicable. So sort of kind of try for geographical diversity. The current commissioners, I found this interesting as a practicing lawyer, the current commissioners, there are only 6 of them. I don't know why there's not 7 commissioners, because there's supposed to be 7, but there are 3 Democrats, 2 unaffiliated, and 1 Republican on the current commission. The 3 of the 6 commissioners, their terms expire March 16th, 2019. At the end of this, in my little segment, I'm going to make a couple broader conclusions. One of them is elections matter, right? Because who our governor is and who our state senate is means who's on this commission, right? And who's going to appoint the three of these commissioners whose terms end March 16th, 2019. All right, what can the commission do? The commission can make regulations, I'm not going to go through all their powers, but make regulations. That's one of the things the commission can do. That is very important. Why? Take, for instance, sexual orientation. Sexual orientation was added as a protected class in Colorado, not federal law, but in Colorado in 2008, right when we had a Democrat-leaning governor and legislature. The CCRC commission, they make regulations about sexual orientation and what that means. And if you want to find out what's legal in Colorado as to transgender, you look at the regulations, which again are made by the commission. I won't go into that now, but when you read them, you can see, oh, these regulations about transgender rights were written by a more liberal-leaning group of commissioners. Keep going. What else can the CCRC do? They can hold hearings, which is what they did with Jack Phillips, and the hearings that were held, as Eric Baxter talked about, some of the statements by the commissioners themselves were anti-religious in flavor, which is why Kennedy and the majority in the Supreme Court case overturned it, because they said the government itself, i.e. the commission, can't be against religion when they're supposed to be considering, when they're supposed to be respecting religious rights of all the people that come in front of them. But they make regulations, very important, hold hearings, very important, appoint ALJs, so it's the commission that appoints the ALJ, right? So again, when your fact finder is so important, if you're in front of the commission, they appoint the ALJ, they're going to appoint somebody that they like to be the fact finder. Okay, very important. What else can we do? Skip all that. Okay, the hearing process I've already described to you. Okay. What remedies can the commission order under the statute? Important. First, they can give an order requiring the respondent, Jack Phillips in this case, to cease and desist from whatever discriminatory action he is taking. Second, they can order someone to take such action as it may order in accordance with CADA, the Anti-Discrimination Act. Now, as you listen to that, you go, wow, that's very broad. And I say as a lawyer, you're right. That is extremely broad. They have massive latitude to make any sort of order. So what sort of order did they give to Jack Phillips? As Eric Baxter mentioned, they required training. They required staff training. Now, I've never dug into to figure out exactly what that staff training was exactly, but it does chill me as an American and as a lawyer to think this commission group ordered some sort of staff training to Jack Phillips and the other people that worked with him to teach them what? To teach them that their religious beliefs were wrong? Well, that would be horrifyingly scary. To say, oh, you must comply with the law and here's what the law is. They probably already knew that after several years of litigation. I don't know, but that piece of it really concerned me and continues to concern me. But that they have that latitude for what sort of remedies they can give. What else? Okay, so what happens if you don't like the decision that the commission gives, like in Jack Phillips' case? You can appeal. Where do you appeal to? You appeal to the Colorado Court of Appeals, which is, of course, what Jack Phillips did. He lost at the commission level. He appealed to the Court of Appeals. But what's important as a lawyer is you don't go to a trial court where you can have a new fact finder, i.e. a judge, who's supposed to be independent of all these things. You go directly to the Court of Appeals. So it was the Court of Appeals that heard his appeal, and then the Court of Appeals supported the commission's decision, and then Jack Phillips appealed again on religious liberty grounds. Interestingly, right, his appeal went to the Colorado Supreme Court. They didn't take the case. I found, as a lawyer, I find that fascinating that the Colorado Supreme Court didn't take this case, says, no, this case isn't important enough. And so they appealed to the U.S. Supreme Court, which is unheard of, and the U.S. Supreme Court took the case straight from the Court of Appeals. Very, very unusual. What else? Oh, yeah, so one important rule here is at the Court of Appeals level, findings of fact shall be conclusive as long as it's supported by substantial evidence. So again, the importance of the evidence that is given at the ALJ stage or the commission stage, that's the evidence that must be followed at the Court of Appeals. You can't introduce new evidence, in other words. Okay, now moving on to public accommodations specifically. So we're getting more specific still from what the commission does generally to the Public Accommodations Law, which is what, again, Jack Phillips was fighting. Public accommodations in Colorado is defined very broadly. One part of the Anti-Discrimination Act just incorporates the federal law, which is very broad, and another part defines it itself, which is very broad. Interestingly, the public accommodations definition specifically includes educational institutions, period. Educational institutions with no definition of public or private, with no definition of religious or non-religious. So query the CCU lawyers whether CCU is a public accommodation under that definition. Also, public accommodations statute says that sexual orientation is a protected class. Now again, keep in mind that the protected classes are the ones that are protected under law, right? Because, for instance, when dress designers didn't want to make the First Lady's dress, right? Could she have brought a discrimination claim if she thought, under the public accommodations laws of, say, Virginia, it was because she was a woman that they wouldn't make her a dress, or maybe because of her creed, like her political creed, that they wouldn't make her a dress, then maybe she'd have a case of discrimination there. But if it was just, no, we don't want to make you a dress, or like in restaurants, no shirt, no shoes, no service, right? That's not a protected class. You have to have a lawsuit, you have to be in one of these protected classes. Okay, so for employment, what are the 10 protected classes? Let me go over them because it's good contrast with public accommodations. 10 protected classes for employment: disability, race, creed, color, sex, sexual orientation, religion, age, national origin, or ancestry. All right, you can keep all those in your head. But one little note as to the employment part of the Anti-Discrimination Act. In the statute, there are 2 carve-outs for religious organizations. One is you're not even considered an employer at all if you are a religious organization or association, unless you are supported in whole or in part by public money raised from taxation or public borrowing. So if you're a religious organization, you can discriminate on the basis of employment unless you take public money. Then there's a second carve-out for religious organizations. The employment part shall not apply to a religious corporation, association, educational institution, or society with respect to the employment of individuals of a particular religion to perform work connected with that religion. So, easy example, an evangelical university can hire evangelicals, right? That's the obvious one. Okay, I'm being told to wrap it up, so let me wrap it up. Public accommodations. Okay, so focusing in on public accommodations, two things to say. First, the Public Accommodations Law also prohibits publishing anything saying that we will not respect these protected classes. So, for instance, you can't publish statements like, we will not hire blacks, right? Think of the Jim Crow South. And let me say also, there are 9 protected classes with public accommodations. Let me just mention that religion is not one of them, and age is not one of them. So under the Colorado Public Accommodations Law, religion is not a protected classification. So someone under public accommodations could discriminate because of religion for public accommodations law purposes in Colorado, and it wouldn't matter. Okay. Oh, the last piece I will say is, for public accommodations, you can either go to the commissions, kind of the commission route as I've described, or you can go to court. So you can actually go to court if you want to, but if you're Mullins and Craig, you don't want to go that route. You don't want to be in front of a judge and get a jury. You want to go the other route. One thing that I thought of as a lawyer is, if you want to change the law, Centennial Institute, is have a right of removal, that if someone files with the commission, you can actually remove the case to court, so that you as the defendant don't have to follow where the plaintiff wants to go. Okay, I will stop and just give my 3 concluding comments, which is 1, elections matter. Who people elect matters. 2, culture matters. Dean John Garvey, who I think is was dean at the Catholic Law School, said, if people don't care about religion in America, they're not going to care about religious liberty in America. And the third thing I will say is, by and large, I think the law states, generally speaking, that commerce is governed by the state where you're doing commerce. So if Jack Phillips wants to sell cakes generally, or other products, he's going to be governed by the laws of Colorado by and large. Justice Kennedy says that in his majority opinion. Justice Gorsuch says that in his concurring opinion. And Justices Kagan and Breyer say that in their concurring opinion in the Masterpiece Cake Shop. So this idea that Jack Phillips or other vendors, by and large, will put aside expressive conduct for now, which we can talk about later, but by and large, you're going to have to follow the laws of the state. All right. Sorry, hope that wasn't too boring.